My dear friends, good evening. My dear friends, today we are discussing the judgment passed by the Supreme Court in Lalita Kumari versus Government of Uttar Pradesh. So, friends, this is a matter in which the question which was decided was as to whether a police officer is bound to register an FIR when a cognizable offence is complained of by the complainant, or does he enjoy some sort of a discretion to hold a preliminary inquiry before registration of an FIR. So there was a divergence of opinion among many police stations and also among many courts as to whether the police officials enjoy a discretion or not to hold a preliminary inquiry even when the commission of cognizable offence was complained of by the complainant. So basically, the incident that triggered this passing of this judgment was that a petition under Article 32 was filed before the Honorable Supreme Court of India, where a father approached the court stating that his daughter was kidnapped by somebody. So this Lalita Kumari was a minor girl, and a habeas corpus petition was filed by her father, namely Shri Bhola Kamath, and he wanted a habeas corpus to be issued by the Honorable Supreme Court for the protection of his minor daughter who had been kidnapped. So basically, long story short, the petitioner came before the Supreme Court and he said that after persuading the superintendent of police concerned, the FIR had been got registered against certain kidnappers, but the police were yet not taking positive steps to cause apprehension and arrest of such persons whose names had been given by him. Then this case was before DB, two-judge bench, but the two-judge bench thought it wise to further send this matter to the three-judge bench, which ultimately was pleased to send this matter for adjudication before the constitutional bench, comprising 5 judges. So basically, as we would see during the course of our discussions as to what all judgments had been referred to by each of the sides. Now, when the matter was referred to the constitutional bench, the question that required determination was on the interpretation of section 154, 156 and 157 of the CRPC. So before we move ahead into this judgment, it would be pertinent and important for us to go through the bare wording of section 154 of the CRPC once. I'll try to put a snapshot of section 154 on this video as well for reading purposes. Now 154 can be broken up into 3 parts. Part A, which deals with the fact that if any person makes any complaint regarding the commission of the cognizable offence to an officer in charge of a police station, then such offence or such complaint shall be reduced into writing under the instructions of such officer. B, it also says that such a complaint, when reduced into writing, shall be signed by the person complaining or making such complaint. C, it says that the sum of such complaint shall also be entered into a book to be kept by such officer in such form as the state government may prescribe. So basically it deals with the lodging of an FIR. Then the second part of section 154 says and implies that a copy of the information should be forthwith supplied free of cost to the informant. This is very important. So first of all, when a cognizable offence is committed, then even if an oral complaint is made before an officer in charge of a police station, then that should be reduced into writing either by such officer or under his directions and instructions. Secondly, it shall be signed by the person, by the informant, by the complainant. Thirdly, it shall be entered into a book to be maintained, to be kept by officer in charge of the police station. Second part of section 154 deals with the free copy of such information, when reduced into writing, should be forthwith supplied free of cost to the informant. And the third part of section 154 deals with the fact that in case the officer in charge of police station refuses to lodge to reduce such complaint into writing and to enter it into the books, then such person, the informant or the complainant as may be, has an opportunity, has an option to send a written complaint to the superintendent of police, SP. So such superintendent of police shall then substitute the officer in charge of the police station and shall have all rights and powers to investigate into the complaint or the written application that has been made to him. And in case he is convinced that a cognizable offence has been committed, then he shall have powers to investigate it and to get an FIR lodged. So this way 154 can be broken up into three parts. Move ahead with this judgment, friends. Section 156 of the CRPC has also been discussed. If you would note that section 156 is the same section in which private complaints are filed by us lawyers when the police officers fail to lodge an FIR at the behest of a complainant or an informant. So section 156 subsection 1 and subsection 3 of section 156 are quite relevant to the issue at hand. So 156 subsection 1 says that every officer in charge of a police station without the orders of a magistrate shall have rights or powers to investigate into the commission of a cognizable offence. So this means that a police officer in charge of a police station does not need to wait for the orders of a magistrate before he takes in his hands investigation where a cognizable offence is said to have been committed. And the other relevant portion of section 156 is the third subsection, which says that any magistrate empowered under section 190 of CRPC may order such an investigation as above mentioned. That's it. So where a police officer, we may interpret it this way, that where a police officer fails to do his duty, then even a court can order that such an investigation be completed. As we read the judgment further, it lays down the viewpoints of several esteemed advocates who had appeared before the Supreme Court in this case when the proceedings were going on. Like, say for instance, Dr. Ashok Dhamija, who appeared for CBI, his statements and his assertions have been duly recorded. Mr. K.V. Vishwanathan's assertions have been recorded, so on and so forth. Mr. Kalyan Bandopadhyay, senior counsel appearing on behalf of state of West Bengal, his contentions have been recorded. Dr. Manish Singhvi, who appeared as additional advocate general for the state of Rajasthan, his contentions have been given, they have been duly recorded, and so on. But the leading light and the most important contentions that I found were those of Mr. Siddharth Luthra, because his contentions were poles apart from the contentions taken by all the other counsels. Mr. Siddharth Luthra, who was additional solicitor general appearing for the state of Chhattisgarh, he elaborated various judgments which held that an investigating officer, first of all, let me tell you what the viewpoint of the other advocates was. Other advocates who appeared on behalf of several states, they said that police officer in charge of a police station does not have any discretion in conducting a preliminary inquiry before lodging an FIR once the cognizable offence has been committed. So they went back to the bare wording of section 154, and they said that section 1, the words shall have been used by the framers of this code, by the framers of the legislation, and therefore the police officer in charge of a police station does not enjoy any immunity, any discretion to hold a preliminary inquiry. So all the contentions were around this particular statement. While Mr. Siddharth Luthra was the only one who contended that in matrimonial, commercial, medical negligence, corruption related offences, there exists certain provisions for conducting an inquiry or preliminary inquiry by the police without or before registering an FIR under section 154 of the code. And to this extent, he also assisted the court by handing over or reading out the names of certain judgments passed in Bhagwant Kishore Joshi, P. Sirajuddin, Rajinder Singh Katuj, Bhajan Lal, so on and so forth. Mr. Luthra also pointed out that preliminary inquiry before registration of an FIR should be held permissible. So these were his contentions. He's the only one out of so many lawyers who contended that there should be a preliminary inquiry before an FIR is lodged. He said that the power to carry out an inquiry or preliminary inquiry by the police which precedes the registration of FIR will eliminate the misuse of the process, as the registration of FIR serves as an impediment against a person for various important activities like applying for a job, applying for a passport, etc. So therefore, he pleaded before the court that certain guidelines should be framed for certain category of cases in which preliminary inquiry should be held permissible. Since I'm already taking names of a few advocates, it would be relevant to take name of Mr. Shekhar Nafade as well, learned senior counsel who appeared on behalf of state of Maharashtra, and he also in very strong words contended that there should be a discretion given to the police officer in charge of a police station to conduct a preliminary inquiry, and only thereafter, if he is satisfied that there is a prima facie case made out, then only he should register an FIR and initiate investigation. In support of his contentions, he also laid down the illustration whereby it has been held in one of the judgments in Tapan Kumar Singh and Jacob Matthew that no medical professional should be prosecuted merely on the basis of allegations in the complaint, because if this was permitted, then a lot of doctors merely on the basis of apprehensions would land behind bars after showing medical negligence. So he said that section 154 cannot be put in a straitjacket formula and things like that. As we move further, the court does take into consideration section 166A of the CRPC, which lays down that in subsection C, it lays down that if any person being a public servant fails to record any information given to him under subsection 1 of section 154 of the CRPC in relation to a cognizable offence punishable under section 326A, 326B, section 354, section 354B, section 370, 378A, 376, 376A, 376B, 376C, 376D, 376E, and section 509 shall be punished with rigorous imprisonment for a term which shall not be less than 6 months, but which may extend to 2 years, and shall also be liable to fine. Now hold on for a second. This is very, very important. Section 166A, subsection C. It lays down that if you fail to reduce into writing and record any information given to you under section 154 that we just discussed in relation to the commission of a cognizable offence under a few sections, some of them are related to rape, and then section 509 is also there, 326A, 326B are also there, 354, 354B. Then such a public servant shall be punished with a rigorous imprisonment for a term which shall not be less than 6 months. So punishment has been prescribed for a public servant if he refuses to or fails to record any information given to him of the commission of a cognizable offence, which is punishable by the sections that we just discussed. So I do not see any reason to believe that the Honorable the Supreme Court was swayed by any other swayed to any other direction, but to say that the words as used in section 154 CRPC should be very strictly interpreted, and the term shall that has been used in section 154 should be very strictly interpreted, and that even if tomorrow it is found out that the information was a false information on the basis of which the FIR had been filed, then that is a matter of investigation. But if prima facie from the disclosure made in such statement it is found that a cognizable offence has been committed, then the first duty of a police officer in charge of a police station would be to lodge an FIR, first information report. Why this should be done, what are the reasons behind lodging an FIR quickly, is that yes, so the court says that although there is it is not that the CRPC does not have or does not use the terms like inquiry or preliminary inquiry to be conducted, but it says that these words preliminary inquiry and inquiry as reflected in sections 159, section 202 and section 340 of the CRPC reflect an inquiry that is to be committed and conducted at the level of the court towards achieving judicial goals and not by the police. So the court says that an FIR should be forthwith lodged because of 4 reasons. A, because it is the first step to access to justice for a victim. B, because it upholds the rule of law in as much as the ordinary person brings forth the commission of a cognizable crime in the knowledge of the state. C, because it facilitates swift investigation and sometimes even prevention of the crime. In both cases, it only effectuates the regime of law. D, it leads to less manipulation in criminal cases and lessens incidents of antedates FIR or deliberately delayed FIR. To sum up, the Supreme Court has thoroughly maintained that the officer in charge of a police station does not enjoy any discretion, and if he receives information or even if he does not receive any information, but there is an act or conduct that he suspects, reasonably suspects that cognizable offence has been committed, then he shall forthwith lodge a first information report. However, certain exceptions have been carved out, which are made out well reflected towards the very fag end of this judgment. So, types of cases in which preliminary inquiry is required to be conducted, though it depends upon the facts and circumstances in each case, but certain categories have been carved out, which are A, matrimonial disputes and family disputes, B, commercial offences, C, medical negligence cases, D, corruption cases, E, cases where there is abnormal delay and laches in initiating criminal prosecution, for instance, over 3 months delay in reporting the matter without satisfactory explanation, explaining the reasons of delay. Though I would have personally liked the Honorable Supreme Court to have applied a little more mind towards the fact that once an FIR is registered, even on the basis of a false complaint or a false information being given by a complainant or an informant, if it is not in the discretion of an SHO or an officer in charge of a police station to conduct a preliminary inquiry, it can lead to a chaotic situation, especially in a country like India, where the access to justice is highly curtailed due to many reasons for every person. Say, for instance, tomorrow if a woman comes and goes to an officer in charge of a police station, says that Mr. X has been aggressive towards me and she's outraged by modesty and that I've been sexually exploited by him. So, assuming that if she is making a false report, giving a false information to the officer in charge of a police station, then there is no reason for the police officer, even in the heart of his hearts, he knows that the information given to him is false. He does not have an option. He has to lodge an FIR. Once an FIR is lodged, the police will be after your blood. And if the police catches hold of you in a country like India, very difficult to secure a bail in 376 or allied offences. It is absolutely next to impossible to secure an anticipatory bail until unless you have a very foolproof case. Even if you are arrested and you apply for a regular bail in such heinous crimes, it is extremely difficult. So you have to wait for the circle to complete, wait for the investigation to complete, assume and pray that the investigation goes the right way, and then really wait hard, wait long before you can be freed from the clutches of law. I think further exceptions ought to be carved to this general rule.